So friends, a former New York prosecutor who investigated the crimes of Donald Trump just called out Jim Jordan and his congressional committee to obstruct justice. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, former prosecutor Mark Pomerantz, who investigated the New York State crimes of Donald Trump when Pomerantz was a prosecutor with the Manhattan District Attorney's Office, well, Pomerantz was served a congressional subpoena for testimony. And you know who served him? None other than Republican Representative Jim Jordan, who himself criminally defied an identical congressional subpoena. But unlike Jordan, Pomerantz complied with the subpoena. He showed up, he appeared, and then he took apart, piece by piece, Jim Jordan and his dirty little congressional committee to obstruct justice to protect Donald Trump. Here is the new reporting from NBC News. Headline, former Manhattan prosecutor frustrates House Republicans at deposition on Trump case. And that article begins, a former prosecutor who once oversaw the Manhattan District Attorney's Office investigation into former President Donald Trump frustrated House Republicans on Friday by repeatedly saying during a deposition that he would not answer their questions about the DA's probe. Mark Pomerantz spent roughly 6 hours with members of the GOP-led House Judiciary Committee, which really should be renamed, the House Committee to Obstruct Justice to Protect Donald Trump, which is investigating Manhattan District Attorney Alvin Bragg's prosecution of Trump. In his opening statement, Pomerantz blasted the inquiry as political theater and condemned the panel's use of a subpoena to compel his participation. So friends, rather than continuing on with the reporting, let's go directly to Mark Pomerantz's opening statement that he gave to Jim Jordan's committee on Friday. And fair warning, I will probably be making some of my own editorial comments and observations while I read this letter. Here is how Mr. Pomerantz's opening statement to the House Judiciary Committee starts. I am here because I respect the rule of law. I spent my working life in service to the rule of law, and the rule of law requires a witness to appear for testimony in response to a subpoena, so I am present as required. Friends, make no mistake about it. That was a direct slam of Jim Jordan. That was a direct rebuke of Jim Jordan. That was calling Jim Jordan out for criminally defying a congressional subpoena. The opening statement continues, what I do not respect is the use of the committee's subpoena power to compel me to participate in an act of political theater. This deposition is for show. I do not believe for a moment that I'm here to assist a genuine effort to enact legislation or conduct legislative oversight. We are gathered here because Donald Trump's supporters would like to use these proceedings to attempt to obstruct and undermine the criminal case pending against him and to harass, intimidate, and discredit anyone who investigates or charges him. Any questions? Jim? The opening statement continues. Fortunately, I do not have to cooperate with the cynical histrionics that this deposition represents. Although the rule of law compels me to be here, it does not require that I play a substantive role in your theatrical production. Under the law, I can decline to answer your questions for several reasons. In other words, Jim, you're about to be schooled. You might want to sit back, get comfortable, take off your Wait, never mind. Pomerantz opening statement continues. First, I have been instructed by the Manhattan District Attorney's Office that I should maintain that office's claims of privilege and confidentiality in order to protect the integrity of the pending prosecution and continuing investigation of Donald Trump. I intend to honor the District Attorney's request, and I will not answer questions to which the District Attorney objects. Although I have written and spoken publicly about the Trump investigation, I did so before any criminal charges were brought against Mr. Trump. Now that a grand jury has indicted him, the circumstances have changed. With formal charges now pending, the rule of law is best served if the merits of the case against Mr. Trump are litigated before the court that is hearing that case. This is neither the time nor the place for me to answer questions about the investigation or the pending indictment over the objection of the prosecutors. The charges against Mr. Trump should be heard and decided by a judge and a jury before politicians second-guess their merits or the decisions to bring them. That's how our system works. Those who claim that they respect the rule of law should wait for the courts to do their work. Second, the rule of law also affords me a personal privilege not to answer your questions. Under the Fifth Amendment to the Constitution, no person may be compelled to be a witness against himself or herself in a possible criminal case. Shortly before the publication of my book, the District Attorney's Office warned me that I could face criminal liability if, among other things, I disclosed grand jury material or violated a provision of the New York City Charter dealing with the misuse of confidential information. When we were before the United States District Court on April 19th, a lawyer from the Manhattan District Attorney's Office said that my book, quote, exposed me to criminal liability. While I am certain I broke no laws, I am not required to answer questions if my answers might be used against me in a criminal prosecution. The Fifth Amendment is a protection for all citizens, including those who have done nothing wrong. Therefore, and on the advice of counsel, I will invoke my rights under the Fifth Amendment, and I will not answer any questions that could conceivably be used against me in a criminal case. Finally, the rule of law permits me to refuse to answer questions that are not pertinent to a legitimate legislative function or that seek information that is protected by the First Amendment's guarantee of free speech. Under the Due Process Clause of the Fifth Amendment, I cannot be punished for refusing to answer such questions. There may be other privileges, such as attorney-client privilege or the work product privilege, that are available to me with respect to certain questions. For all these reasons, I will not be answering questions that relate to my work in the DA's office, my book, or public statements I have made in the past. It gives me no joy to invoke my legal rights, but I am glad that the law allows me not to cooperate with this performance of political theater. As an American, I'm privileged to have the legal rights that I assert today, and I'm hopeful that I live in a country that will continue to respect them. Boy, Mr. Pomerantz really said a mouthful, didn't he? Let's go through some of the points he made in his opening statement. First of all, he called out Jim Jordan for unlawfully defying a congressional subpoena, blowing off a congressional subpoena. To be clear, that constitutes the crime of contempt of Congress. Yet the criminal is now issuing subpoenas to others, expecting them to comply. I think that qualifies as irony at a minimum. And Mark Pomerantz also said, I am declining to testify because the Manhattan District Attorney's Office told me I shouldn't be answering questions. Why? Well, because since the time I last made public statements in my book or otherwise, the landscape has changed. A grand jury has indicted Donald Trump, and he's pending trial. And my testimony could compromise Donald Trump's right to a fair trial. It could even compromise the right of the people of New York to a fair trial. Because you know what? The people have a right to a fair trial, not just the defendant. So that was another basis he gave for declining to testify. And then interestingly, he also invoked his Fifth Amendment right against self-incrimination. Friends, that one surprised me a bit, but let's talk about it. The reason he gave for that is he said, you know, recently one of the attorneys from the Manhattan District Attorney's Office suggested I might have some criminal exposure for the things I put in my book. Now, he said, I disagree with that. I did nothing wrong, but the fact that some prosecutor's office has suggested I may have violated the law and they would be entitled to use my testimony against me if I gave testimony before this committee, I'm going to plead the Fifth. Boy, that would make me uncomfortable as a former career prosecutor and frankly as a law-abiding American if I really believed I had done nothing wrong, I had committed no crime. And the standard to plead the Fifth, to invoke your Fifth Amendment right against self-incrimination is if your truthful testimony would tend to incriminate you, you can decline to testify. You can plead the Fifth. But here's the thing. There is a way to challenge somebody's invocation of their Fifth Amendment right against self-incrimination. And this is going to take us a minute, and we're going to have to go to a Team Justice Law School class here. But let's kind of talk through how Jim Jordan could challenge Mark Pomerantz pleading the Fifth if Jim Jordan wanted to. We'll put a pin in that. So they could go to court to try to enforce the subpoena, right? They could go to court, they being the House Judiciary Committee, this nefarious committee trying to, block prosecutions against Donald Trump. They could go to court and try to convince a judge that Mark Pomerantz doesn't have a legitimate Fifth Amendment right against self-incrimination because he couldn't possibly incriminate himself in any way. That issue can be litigated by a judge, and a judge would rule either yay or nay that it was a properly invoked Fifth Amendment right against self-incrimination or that it wasn't. And if it wasn't, the judge could order Mark Pomerantz to testify. Here's the thing, friends. Jim Jordan has been yelling and screaming and yammering about how this whole prosecution in New York against Donald Trump is a witch hunt, political retribution. Donald Trump committed no crimes. He shouldn't be prosecuted. So what is Jim Jordan asserting? That the district attorneys who worked on the Trump investigation and who continue to work on the Trump prosecution committed crimes by wrongfully bringing criminal charges against Donald Trump. If that is the narrative Jim Jordan is trying to sell to the American people, at least those gullible enough to fall for it, well, then he can't go into court and take the position that Mark Pomerantz can't possibly incriminate himself. Look, Jim, everything you've been saying suggests that you believe, BS though it may be, that Pomerantz and Bragg and everybody else who's prosecuting or investigating Donald Trump in New York are committing crimes because they're just going after an innocent man for political reasons. Jim, you're not a strategic thinker. You've been made to look a fool. Why? Because you are acting foolishly, nefariously, trying to do Donald Trump's dirty bidding. I would say you ought to cut it out, but you are what you are. But I suspect this will not go any farther. They will not try to enforce the subpoena and compel Pomerantz testimony because they don't have a leg to stand on, because they're playing a bunch of stupid, dirty reindeer games trying to obstruct the legitimate prosecutions of Donald Trump. and Jim Jordan and company will fail, and they will be made to look just as foolish as they are. And then eventually, friends, eventually, justice will win the day. Because justice matters. Friends, thank you for bearing with me through that long explanation. As always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.